If you'll try it for 1 year, if you are not fully satisfied at the end of that year, I'll give you your money back. That is Robert Morris on stage in February 2022 at Willow Creek Community Church outside Chicago, a church that was not even his own. The offer was simple. Tithe. Give 10% of everything you earn for 1 year. If you are not satisfied, you get your money back. He added that in 22 years of leading his own church, no one had ever asked for it. Here is the number that guarantee was sitting on top of. Gateway Church in Southlake, Texas. Roughly $100 million a year in revenue, at its peak one of the largest churches in the United States. And attached to that money, according to a federal lawsuit filed by the church's own members, a specific promise. That 15% of every tithe dollar would go to global missions and Jewish ministry partners. 15% of $100 million is $15 million a year. In October 2024, 4 of those members asked for the refund they say they were promised. When they did not get it, they sued. Breach of contract, fraud, and racketeering. Under RICO, the federal statute written to prosecute organized crime. On June 23, 2026, a federal judge threw the entire case out. Not because he found the allegations false, he never reached that question. He ruled that no civil court in the United States is permitted to ask it. That distinction is the entire story, and it means the money-back guarantee was real, and that it was never at any point enforceable. Start where the money started. Gateway Church was founded in 2000. Small, a handful of people. Within 2 decades, it had grown into one of the largest megachurches in America. More than 100,000 active members across multiple campuses by the church's own count. Robert Morris was its founding pastor, and he was not only a pastor, he was a brand. His book on tithing sold millions of copies. One edition carried a subtitle that tells you exactly what was being sold. The Simple Secret of Achieving Guaranteed Financial Results. He had a television program carried in more than 190 countries. He sat on a sitting president's faith advisory board. He was, by any measure available in American religion, a made man. And the engine underneath all of it was the tithe. 10%. Not suggested. Taught as an obligation, with a promise of return attached, which brings us to the number this whole case turns on. The plaintiffs allege that Morris and other church leaders told the congregation that 15% of all tithe dollars would go to global missions and to Jewish ministry partners. Stop and notice what kind of statement that is. It is not a doctrine. It is not a belief. It is not a claim about heaven or salvation or anything a court could never test. It is a percentage. It is arithmetic. It either happened or it did not. Hold on to that because a federal judge is about to disagree with you. The first crack in the story does not come from a journalist. It comes from an accountant the church hired. Alan Shoulders was a partner at an international accounting firm preparing to retire when he was approached by Tom Lane, then Gateway's senior executive pastor, about running Gateway Global Ministries. The pitch, as Shoulders described it, was extraordinary. He would be responsible for giving away somewhere between $11 and $22 million a year. That figure came straight from the promise. 15% of roughly $100 million in annual revenue meant about $15 million every year moving through his office. He took the job in 2011. He stayed until 2014. And what he has said publicly on the record is that the church never gave more than $3 million to global missions in any year he worked there. Not $15 million. 3. He also said he identified 2 transfers he could not get explained, totaling $1.5 million. He later told reporters he had been a fool to trust Gateway with his own money. Now, Gateway disputes all of it, and the church's answer belongs here, not in a footnote. Gateway has said that over an 11-year period, its global missions budget averaged around 20%, with a low of 17% and a high of 24%. On that account, the church did not fall short of the promise. It exceeded it. An elder, Tra Wilbanks, told the congregation the church had been audited every year since 2005. Shoulders, a career auditor, responded that Gateway Global Ministries was not subjected to any audit procedures during his time there. So which is it? 20% or $3 million? Here is the problem. When reporters asked Gateway to release the audits, the church declined to release them. They are not public. And there is no filing you can pull, no form you can request, no agency that holds a copy. For a church that raised roughly $100 million a year from the public, there is nothing for the public to open. That is not an oversight, and it is not a cover-up. It is the law, and it is the first of 3 locks. To understand why this case died, you have to understand what happens to a dollar the moment it leaves a member's hand. Lock 1. In the eyes of American law, that dollar is a gift. You did not buy anything. There is no product, no service, no delivery date. A purchase creates obligations that a court can enforce. A gift, as a rule, does not. That is why the refund promise mattered so much to the plaintiffs. A guaranteed refund is the one thing in this entire structure that looks like a contract. A stated term, an offer, a condition. Remember that. It comes back. Lock 2. Every other charity in America files a Form 990. The food bank files one, the university files one, the animal shelter down the road files one. It is a public annual return, and it lists revenue, expenses, and the pay of the highest compensated people in the organization. Anyone can read it, right now, for free. Churches are exempt from that filing requirement by statute, not by custom, by statute. So a church can raise $100 million a year from the public and never publish a single page describing what happened to it. That is legal. It is the settled design of the system, which leaves the third lock, and the third lock is the one that ends this case. It is called the ecclesiastical abstention doctrine, and it comes out of the First Amendment. The principle behind it is genuinely sound, and I want to give it its strongest form. Civil courts are not allowed to decide religious questions. A judge cannot rule on whether a doctrine is correct. A judge cannot decide who is a legitimate minister or whether a church's mission is being pursued faithfully. You do not want a federal judge with the power to grade a congregation's theology. Nobody sane does. So here is the question this case actually put in front of the court. Is a stated percentage a religious question, or is it a number? The members' lawyers clearly expected that fight because they escalated. In an amended complaint reported in October 2025, they added a racketeering claim. RICO, the statute Congress wrote to break organized crime families, and pointed it at a church in Southlake, Texas. That is how far you have to reach when the ordinary tools do not work. June 23, 2026, United States District Judge Amos Mazzant, Eastern District of Texas. He dismissed all of it. Breach of contract, fraud, RICO, every claim against every defendant. His reasoning was that resolving the case would require the court to examine the allocation of tithing dollars and to determine whether the church's policies were doctrinally correct, matters he described as protected from judicial review. At its core, he found, this was an internal church controversy. He leaned on a recent decision from the Fifth Circuit, McRaney against the North American Mission Board, decided in 2025, which reaffirmed that religious institutions have autonomy over internal management decisions essential to their central mission. Gateway's attorney, Ron Breaux, said the plaintiffs had sought to second-guess Gateway's beliefs about tithing and that the First Amendment prohibits, in his words, such an assault on Gateway's religious autonomy and freedom. Morris's attorney, Bill Matea, put it more bluntly. Courts of law, he said, have no business adjudicating matters of the church and church business, and Morris has denied any wrongdoing with the money throughout. His position is that tithe monies were faithfully and properly stewarded. Now be very precise about what just happened, because almost every headline got it slightly wrong. The judge did not find that the money was misused. He also did not find that it was not. He made no finding at all about where a single dollar went. He ruled that the question is outside the power of a civil court to answer, which means something colder than a verdict. If every allegation in that complaint were false, the outcome is dismissal. And if every allegation in that complaint were true, the outcome is exactly the same dismissal. Same door. Either way, that is what abstention means. It is not a scoreboard, it is a jurisdiction. The people who filed this were not activists. Catherine and Gary Leach, Mark and Terry Browder. Members, tithers, people who gave for years. The suit also named former executive pastor Tom Lane, founding elder Steve Doolin, and former executive global pastor Kevin Grove. The claims against all of them were dismissed. None of them has been found liable of anything. But the cost of this story did not land on the defendants. Look at who it landed on. Attendance at the Southlake campus fell by about 40%. Across all 7 campuses, it dropped by nearly a quarter. An elder, Kenneth Fambro, told the congregation that tithing had fallen by 35 to 40%, and that ministry changes and staff reductions were being evaluated as a result. In June 2025, the layoffs came. The church said giving had not mirrored attendance, given the ongoing issues related to its former pastor. Staff were offered 1 month of severance and benefits per year of service, capped at 4 months. So the children's ministry coordinator lost a job, the audio engineer lost a job, the campus administrator lost a job, and the members who had written the checks for 20 years were told by a federal court that they had no standing to ask what the checks had bought. Meanwhile, and this is the part that changes the temperature of the whole story, the founder was in court too, over money, his own. First, the fact that is not in dispute, stated once and plainly. On October 2nd, 2025, Robert Morris pleaded guilty to 5 felony counts of lewd or indecent acts with a child. He admitted abusing a girl over a period of 4 years, beginning when she was 12 years old. He was sentenced to 10 years with all but 6 months suspended, 9.5 years of probation, lifetime registration as a sex offender, $270,000 in restitution to the survivor. He served 6 months and was released on March 31st, 2026. Now the money. 5 months before that guilty plea, in May 2025, Morris sued Gateway Church over his retirement package. His attorneys alleged that the church's elders had orally promised him $800,000 a year until he turned 70, and then $600,000 a year for as long as he or his wife is living, plus more than $1 million from a retirement account. For context on what a pastor's money looks like at this level, property records reported by the Roy's Report tie Morris to a 370-acre ranch valued around $8 million, a Colleyville mansion he owned from 2017 to 2022, a home in Westlake sold in July 2024, 1 month after he resigned, and a lake house bought in 2021 for around $1.7 million. Nobody has proven, and I am not suggesting, that any of those came from tithes. There has been no such finding. Gateway was asked directly what it paid Morris over the previous decade. The church declined to say. The one place the public can see any number at all is the tax return of his separate evangelistic association, which is not a church, so it has to file. Those filings show $350,000 in 2018, $300,000 in 2019, and $200,000 in 2022 for a role listed at 15 hours a week. Gateway's answer to his retirement demand was that it had no record of agreeing to any such payments, and that there is a written agreement providing that no benefits are paid if a departure is related to a felony conviction or plea. And then, on May 12, 2026, both sides walked out of the public courtroom. They agreed to dismiss the state case and move the dispute into private arbitration, under Morris's own employment contract. Binding Christian conciliation, conducted privately. The terms were not disclosed. It is not publicly known whether he has received anything. Now put the 2 dates side by side, because this is the shape of the whole story. May 12th, 2026. The pastor's money question gets a forum. Private, closed to the public, but a forum, because it rested on an employment contract and a contract is enforceable. June 23rd, 2026. 42 days later. The congregation's money question gets a doctrine and a closed courthouse, because it rested on a gift and a gift is not. That is not a conspiracy. It is worse than a conspiracy. It is the design working exactly as written. The story is not finished. On July 17, 2026, attorneys for the former members filed an appeal with the United States Court of Appeals for the Fifth Circuit. The filings reported so far do not indicate the grounds they intend to argue. But understand the size of what the appellate court is now holding. The Fifth Circuit covers Texas, Louisiana, and Mississippi. If a specific numerical promise about where donations go is an ecclesiastical question, then in 3 states, no court can weigh any church's representation about its money, no matter how specific that representation was, and no matter how many people relied on it. And this is not the only case where that doctrine is doing work. The woman Morris admitted abusing has also sued Gateway and several former elders for defamation over how they described her publicly. In February 2026, a Texas judge ruled that suit could go forward. Gateway and the elders appealed, arguing the trial court has no jurisdiction because the claims concern internal church matters, protected by the same ecclesiastical abstention doctrine. Texas's Fifth Court of Appeals stayed the proceedings while it reviews that argument. No findings have been made in that case, and the defendants deny the claims. So the same shield that was raised over the tithes has been raised over the defamation claim. Whatever you conclude about the doctrine, it is not being used narrowly, and there is a real argument on the other side, which I am going to state as strongly as I can. That doctrine protects the tiny immigrant congregation from a hostile judge exactly as it protects a $100 million church. If a court can audit a church's spending priorities, a court can shape a church's mission. Serious people defend this doctrine for that reason, and they are not fools. But the counter-argument is just as plain. Nobody asked a judge what Gateway should believe. Nobody asked a judge to rule on tithing, or on scripture, or on whether the church's mission was faithful. They asked whether a stated percentage was met. 15%, yes or no. Whether that is a question about God or a question about arithmetic is now genuinely in front of a federal appeals court. Nothing in the public record proves that Gateway Church stole anything. No court has found it. The defendants deny it. Morris says the tithes were faithfully and properly stewarded, and the church says its missions giving averaged around 20%. Take every one of those statements at face value. The problem survives anyway. Because the darkest fact in this story is not that money went missing. It is that there is no mechanism by which anyone could ever find out. No public return because churches do not file one. No contract because a tithe is a gift, and no court because the courthouse door is shut by a doctrine older than anyone in this story. The refund guarantee was the one thread that looked like it could pull all of this into daylight. A stated promise with a condition made to people who acted on it. And when it was finally tested, the promise turned out not to be a contract at all. It turned out to be theology, and theology is exactly the thing a court is forbidden to grade. None of these three locks is permanent. The church exemption from the Form 990 is a line in the tax code, and Congress can amend a line in the tax code. The abstention ruling is on appeal right now, and appellate courts reverse district judges every single week, which means the honest ending here is not an outrage. It is a live question with a docket number. If you want the next autopsy, the fortune, the pulpit, and the paperwork that makes it invisible, subscribe. And tell me in the comments, should a church that takes in $100 million a year from the public file the same public return that every other charity in America has to file? Or is that number nobody's business but the church's?